As promised. Okay, thank you everyone for joining us. Today we have with us some awesome staff from Garfunkel Wild, a law firm that specializes in employment law. Today we have Jeff Adest, Sandra Jensen, and Salvatore Puccio to talk about the New York State vaccine mandate that I know there are plenty of questions on. So Sandy, Jeff, and Sal will be going through what we know, what we don't know, the guidance that we have received from DOH to date, and some considerations for all of you as you go forward in compliance with that guidance. So I will turn it over to the Garfunkel Wild team now, and take it away, guys.
Thank you. Good afternoon, everyone. Just to let you know about us, so Sandy and I work in the healthcare space and do a lot of work for FQHCs, and Sal is an employment attorney specializing in the kinds of issues that we're dealing with now. What we thought we would do today is walk through a little bit of an overview of what the requirements are and try to address some of the questions we've been receiving already. And then obviously, if you have more questions, we're happy to answer them. So like in any other presentation we do, I think the slides will be going out to everybody. If not, you could, email us and we'll send them to you, so you don't have to be sitting there taking pictures of the screen as we're going through it. And it's being recorded, obviously, so it'll go out to you that way as well. So first of all, we want to thank CHCANYS for giving us the opportunity to speak to you today. And I guess that we've been getting a lot of questions about this from FQHCs. I would say more from FQHCs than from many other providers, because it seems like for many of you, there is a significant portion of your staff who is not vaccinated, and come 2 weeks from yesterday, you may have a problem in terms of keeping the doors open or keeping fully staffed, to be able to continue operating. So I'm not getting into any of the politics about it. We're not getting into the politics about it today, right? Whether you believe people should be vaccinated, should not be vaccinated, should be a mandate, should not be. We sort of are where we are in terms of there is a mandate. And so we're here to try to give you an overview and try to help you walk through some of the things that have happened. We will talk to you about the state mandate. We will also briefly discuss the federal mandate and some OHSA requirements that some of you are aware of, and I think others may not be aware of. We will also talk to you about the case where the court ruled that there has to be a religious exemption, or at least gave a temporary injunction for enforcing a religious exemption. So we'll walk through all of that. Again, I ask that you just bear with us in terms of your view may be that everyone should be vaccinated, and if they can't be, then they should not be coming through the door, and that's fine. But for the centers that have 25 or 30 or 40% of their staff who are not vaccinated, they may need to take a different position regardless of what anyone believes individually. So those of you who have listened to our webinars before, we're going to follow sort of the same format where Sandy is going to walk through the requirements, and Sal and I will jump in with some color as she's going through it.
Okay, great. I think we can advance to the next slide. So our slides are really detailed, and there's a lot of information so that you can go back and use it as a reference if you have a question that comes up. So the first slide just summarizes where we are. So we have emergency regulations that took effect in August. For FQHCs, you're considered diagnostic and treatment centers, so you have to come into compliance by October 7th. So what the regs require is that DNTCs continuously require your personnel to be fully vaccinated. And the first dose has to be administered by October 7th, unless there's a medical exemption. So the continuously require personnel to be vaccinated means that by October 7th, you have to make sure that all personnel at least have the first dose, but then you have to make sure that you're following the CDC guidelines and the drug manufacturer recommendations for when the second dose must be administered and any boosters that may come down the line. To help us understand the implementation of the emergency regs, DOH issued FAQs late September. Now, What is not covered in the emergency regulation is an exemption for religion. But as Jeff mentioned, at least temporarily, there is a religious exemption, and we'll talk about it in later slides. Next slide. So covered entities. As DNTCs, you are covered entities, and DOH regulates a number of others as well, including adult care facilities, hospitals. They clarified that it's really any entity for which DOH issued an operating certificate. Now, I know a number of you are also licensed under different agencies like OHSA or OMH Article 31 facilities. DOH indicated that the regulation would not apply to entities licensed under a different agency, but there's an exception to that. If you have a unit within your Article 28 that's licensed by a different agency, this regulation could still apply to the units within that agency. So the idea is that DOH is trying to prevent the spread of COVID throughout your facility to your personnel. So if within your Article 28 facility, if you have a unit that's licensed by another entity, theoretically, if you do not require those staff to be vaccinated, you could still spread COVID to your personnel that provide services under the 28. So one thing you should consider is, the location of your other licensed entity. Does it share the same entrance and exit with the Article 28? Is it completely separate, or is it open space where you're really just going down the hall? Do you have shared staff? It's really fact specific. Next slide. So who are personnel? They include anyone that is employed or affiliated with the FQHC who could potentially expose either patients or your other staff. So that includes employees, contractors, students, volunteers, any members of your medical staff. So again,
right, so, sorry, just to jump in, this is one where people are having a lot of difficulty. We're getting a lot of questions about. So unfortunately, the way this was prepared or drafted, this applies to pretty much anyone who works for you. You may have a billing department which is located completely off-site. They are still subject to these requirements. Right? It's administrative staff. It's any staff that are under your control. I'll sort of preempt some of the questions I think we'll get. Yes, it applies. Even if you put them 2 or 3 people in an office off-site, it still applies. The only exception would be if someone's working off-site by themselves in their own office or from their home, they would not be subject to it. But if they are working together with any other personnel, then they count. We've also had people reach out to say, okay, so can I take them and instead of paying them as W-2 employees, make them into 1099s, into contractors? And the answer to that is they still would be subject to this if they are under your control. And if someone was working for you as a, back office QA person, right, for the last 5 years, and now all of a sudden you're switching them to a contractor, that is not going to change.
But you're saying that remote workers at home are not, if they're fully remote and they're at home and they don't come to the office, they're not covered by this mandate.
They are not, right. There's no mandate if someone's working at home by themselves without any other employee. But you can have 2 people go to each other's homes and work together. But if they are home by themselves, they are not covered, and you can have an exemption that way.
But if, let's say they come in once a month to drop off paperwork or drop off supplies of any kind, and they're your employees, then it could draw them into the definition of personnel again, because they're coming into the facility and they could expose other covered personnel. Okay, next slide. So I think we talked about this. It applies to all personnel. It's not limited to those with patient contact. And again, it's intended to reduce exposure to other personnel or other patients. Next slide.
While we're talking, I see a bunch of questions jumping up about board members. So I'll just briefly say that there is nothing specific about board members. Arguably, right, the solution is to do the board meetings virtual. I would argue that if EPA personnel board members are coming in once a month, they are not people who really are under your control. They are independent, right? They control you, not you control them. And so there is a decent argument that they should not have to be vaccinated. We're hoping there'll be a little bit more clarification about that. Unfortunately, the Q&A, which you probably also did not have information about it, but I think there is some room as it relates to board members.
They are not classified as volunteers?
They are not. Volunteers means people who come in and treat, are involved in the care of patients or in the administration of the care of patients. I don't think they are. I would have a very hard time with DOH coming back and saying, we're going to fine you because some of your board members are not vaccinated when they are volunteers who are required by HRSA to be there. I think you would kind of run into a HRSA saying, we need you to have the board members and have the meetings versus DOH saying you need to be vaccinated. And if you're going to lose your board members over it, right, I think that you have a decent argument to not have to require them to be vaccinated. Again, it's not 100% clear, but it just seems like board members would potentially be an exception to this.
And in talking about volunteers who are covered, those that have a formal relationship with the FQHC and provide regularly scheduled volunteer services. So if you have someone, they come once a month or they come twice a month or every Wednesday, they would be covered. But if you are hosting an event, a holiday gathering, and you're asking for volunteers and they're coming just, you have volunteers just for that event, they would not be covered. So they're not covered for the vaccine mandate. Of course, you'd want to take other precautions as well. We're just talking about the vaccine mandate.
Right, I would look at this somewhat like you look at the PPD and other kinds of things, for your employees that you had in place until now, because this falls under the same group of regulations. And usually your board members are not subject to that, which is part of why we think board members are not subject to this either.
And if I could just jump in on this, on the point Sandy's making about the volunteers, one thing to keep in mind for these regulations in general is that just because the state mandate doesn't require the vaccine mandate or proof of vaccine for your special events, for example, that doesn't restrict you from adding that as an individual element. For example, I have a covered entity who we represent. I'm going to their campus premises for a training similar to this. They've asked me for my vaccination status. They've made me cover it under that. Technically, I don't know that I would apply as we just described, but they've asked that of me and I've complied. Similarly, I have another event later in the fall. It's a dinner event. Again, they've required that type of information, that entity as well. So you can increase it. You don't have to, but you can. And we do get those questions.
So just to follow up on the board members, under the state's flu vaccine guidance, would a board member be required to wear a mask during the flu season if they're frequently in and out of the building?
So I think that's a little bit outside the scope of what we were going to talk about today, but I would say, again, I think the answer to that is no. Again, you can mandate it if you want. I don't think the state is mandating it for the board members.
Yeah, I think the state is relying on the guidance under the flu directives.
They did say to look at the flu vaccine for who is covered, and for the FQHCs that we regularly deal with or consult with, I'm not sure if board members go into areas where there's patients and have contact with patients. This is definitely one area where we're we're coming up with a list of questions that have been brought to our attention, and we're following up with DOH on. I think it's sufficiently unclear that it would be helpful to have further guidance. So we are following up with DOH on it.
Okay, but just to add, this does not apply to your piece of equipment breaks and you have some technician who comes in from an outside company, even though they might come regularly. It does not apply to the person dropping off your mail, even though they might be in your space every day, right? It's only people who are within your control, right? We received a question yesterday. If you're calling an EMT because you have an emergency, the EMTs are not subject to this requirement.
I think next slide, I think that's covered in the next slide too, like what contractors are covered. So it would be individuals who function as employees or staff and are under your control. So leased employees, if you have professional service agreements where you have providers that are rendering services in your facility to your patients, they would be covered. And the FAQs listed out who wouldn't be covered, and it does include, your service techs, vendors, EMS. What's interesting is the laboratory techs who provide services by contract. So I know in some situations, labs can place a laboratory tech within the FQHC, and they have their own separate area, and they might have their own jacket, the LabCorp jacket, and you don't really direct their control, but they're within your facility and they're interacting with your staff. And so that specifically was an example provided as an individual that would not be covered. It seems if they're on a regular schedule, that would be another case where you would want to, make sure that there's appropriate PPE used during the time that they're located in your facility. Next slide. So the COVID vaccine is required unless there's a medical exemption. The only exemption allowed under DOH regs is the medical exemption. There exists the religious exemption, which we'll talk about later, but the regulations only allow for a medical exemption. So for the medical exemption, a licensed physician or an NP has to certify that the immunization is detrimental to a person's health. It has to be based on pre-existing health condition, and the basis has to be supported by generally accepted medical standards. And the exemption is only valid until the immunization is no longer detrimental. So some of the precautions that are listed on the CDC's website and are also included on a link on DOH's guidance include if the person has a moderate or severe illness. So the exemption might be appropriate if a licensed physician or NP determines that's the case, but it would only last until the illness resolves itself. So the documentation has to be clear, the nature and how long it's expected for the exemption to last, any reasonable accommodation granted. So an accommodation could be that you're requiring that the individual wear a mask. And you have to update the documentation. So that means if the status changes and maybe the condition resolves itself or the illness resolves itself, you would have to document that in a personnel record or another appropriate record. Next slide. So that's the link. I'm sure you all have the FAQs. So that's the link that where they give guidance on contraindications and precautions. If the individual has been granted a medical exemption, they can work in the FQHC in their normal duties, but again, they should take other precautions, including a mask. So DOH doesn't require that unvaccinated employees with a medical exemption undergo routine COVID testing, but it could be a consideration.
But Sal, there was just a question that popped up about, can we require the employee to pay for testing if they're have an exemption? Do you want to address that?
Yes, thanks, Jeff. I just saw that pop up. So the general standard here is that if the testing is required for an employer, for an employee to perform the essential functions of the job, that test, medical diagnostic test, must be paid for by the employer. So under that general standard, the employer would have to pay for the test. At the moment, it's debatable whether the test is being required for the employee to perform the essential functions of the job. Meaning, one could argue, well, the alternative I gave you, employee, is go get vaccinated, and then you don't have to take the test. So that's the argument that's being made. That said, right now, until there's further guidance, we are recommending to our clients that they should pay for the tests because, again, the status of the law and the guidance from EEOC that came out earlier in the pandemic with respect to COVID testing to return to work was employers should pay for that because it's part of the essential functions, allowing that individual to perform the duties of their job. And I'll circle back to it at the end, but since we're here now, I'll touch on it briefly. The hope, and it's a big hope, I know, and I'm sure you all feel it too, as we've felt for the last 20 plus months of this pandemic and changing regulations. The hope presently is that when the federal government issues some guidance on the federal mandate for covered entities at that level, that the Department of Labor will specifically address who pays for the tests. And an even bigger question that becomes more difficult is who pays for the time to get the test, meaning your employee has to go out and wait online at CityMD to get the test because they don't feel comfortable having the test done at your healthcare facility. Are you obligated to pay them for that? So those are questions we're hoping for some more guidance on. I'll circle back to them with a little more detail later, but for now, again, somewhat of an open question, but the conservative guidance remains you should pay for the test.
Okay, great. Next slide. So you would be subject to reporting requirements if requested by DOH. And I think you should prepare as if you will be requested by DOH to provide this information. So you would have to provide information on your total number of personnel, how many have been vaccinated, and how many have been granted a medical exemption. The regs also allow them to request documentation of COVID-19 vaccination. So what they require with that is either the CDC card or a statement from the provider that administered the vaccine. You could also use information from the New York State or for New York City, the city's immunization registry. But you should keep documentation of all of this information because you might be requested. You might have to submit it to DOH. In addition, you might have to submit documentation on medical exemptions granted and any accommodation that you gave to address the exemption. With respect to masks, the regulations allow DOH to require that all personnel wear masks, even if they're vaccinated. If the masks are mandated, the regs say that the covered entities, which includes FQHCs, would have to pay for it. Even if they're not mandated, you can require your personnel to wear face coverings or masks. Okay, next slide. So we've been getting a lot of questions about enforcement. What happens if you do not comply? So the regulations themselves, what you saw published, didn't really have anything about enforcement, but they are regulations. And because they're regulations, there's other provisions in the statute that set forth the authority of DOH to come in and enforce their laws and regulations. So one is Public Health Law Section 12. And that imposes a $2,000 penalty for each violation of the regulation. So just a word of caution about that. You might look at $2,000 and say, okay, I have 5 staff that didn't get the vaccine, I'll pay the $10,000 and I'm fine. Each violation isn't defined. So is the violation that the individual is not vaccinated, or is the violation for each day that the individual is not vaccinated? It can be a large number if it was determined that it's for each day. So, just a word of caution about that. And also Public Health Law 2806. There could be an action on your operating certificate. And of course, that it has even bigger ramifications than a monetary fine. So with the 2806, a hearing would be required to take action against the operating certificate. I did list out a second provision which allows an operating certificate to be temporarily suspended without a hearing, but that's if there's imminent danger or a continuing practice or pattern that poses imminent danger. That's a really, really high standard. And if you required masks, I'm not sure if, I'll defer to Sal, who does litigation, but I'm not sure if the state would be able to meet that standard. But, with a hearing, they could take action against your operating certificate. And with the $2,000 penalty, that also does require at least an administrative hearing before they could impose that.
Right. So we understand that you're frustrated as to, okay, what's really going to happen. And we're frustrated as to it also. And we wish we could give you better information. I'll say personally in my gut, I don't think they're walking in on October 8th and shutting down FQHCs, because I think the health system will collapse. And I think that the problem that exists in many of your health centers with people not being vaccinated exists across the board, right? We're hearing the same problems at hospitals, at nursing homes. Nursing homes are going to be tremendously understaffed if they really enforce this. So what's going to happen? We don't know, right? If you have only a small handful of employees and you could terminate them and be in compliance, absolutely you should do that. If you're going to be down, 35% of your staff, of your, your workforce, and you have to close your doors or close programs, you might want to take the risk that DOH is not really going to come in and shut you down. But unfortunately, we can't give you, actual definitive, this is what will happen.
Okay, next slide. So, this is another area where we've been getting a ton of questions. You want to comply and you sent your notice out to staff, and what happens if they still refuse? So you are required to comply with the regulation. We talked about the different enforcement actions that DOH could take against you. So what do you do if your personnel refuse? If they do not qualify for a medical exemption, or for the time being, which we'll talk about in the next slide, a valid religious exemption, then you could place your employee on a leave of absence, or you could terminate them.
Right, just on that point, to the extent that you have union employees, right, what you do to them is subject to collective bargaining. So you could ensure that they do not provide services, but whether that's considered to be a termination or a leave of absence or things like that is something that's subject to bargaining. So you can tell them come October 8th, you can no longer work. You can't tell them you're fired without bargaining for that. And we've been hearing, through various clients that what the unions are asking for is to put the people on a sort of 1 year leave of absence to see what happens with COVID after that, but that they would then get their jobs back in a year from now if COVID went away, hopefully, or the regulation went away. So that's something you need to talk to your labor union attorneys about before you do anything in terms of their status.
And Sal, you can correct me if I'm wrong. I think we've been recommending to our clients that they should document the individual's determination and classify the staff who refuse as ineligible to be employed. Is that correct, Sal? That
is correct. And the reason for that is there's the expectation that employees who are let go, terminated because they refuse to get the vaccine will immediately seek unemployment. And the follow-up question, of course, then from the employer is, well, are they eligible for unemployment? That's still an open question, although we've contacted Department of Labor directly with that question, and they've said they're going to be analyzing it going forward. It will be on a case-by-case basis, and they'll include factors such as what industry the individual is in, what the requirement was for their particular position, and their reason for refusing the vaccine as to whether they are eligible. But the thought process is, and as an employer, you might not care, you might have the feeling, and that's perfectly okay, that, well, if we have to let somebody go, they should be getting unemployment, that's fair. But the position might be, well, if they refuse to get the vaccine and comply, I don't know that I should have to pay for their unemployment. And in that case, if you list them as ineligible because of this state emergency regulation, there's a better chance, or an argument at least, that unemployment would deny that request because, again, it's an eligibility issue, not a choice issue. And look, anyone who's dealt with unemployment knows that you can get very, very bizarre decisions out of that group. They, especially during the pandemic, we've seen them be extremely accommodating to individuals. And quite frankly, I would expect that. So I would not be surprised if folks who are being let go because they're not getting vaccinated, I would not be surprised at all if unemployment said, we're going to give them unemployment. We're going to allow it in this circumstance.
Next slide. Okay, I'm going to turn this over to Sal.
Thank you, Sandy. So as things continue to get muddled and making our jobs as attorneys difficult in analyzing this, and making your jobs as the administrators of your facilities even more difficult, a temporary restraining order was issued with respect to the religious exemption. And as we all know, the state specifically removed that religious exemption that's typically afforded when requiring medical mandates such as the COVID vaccine, which is required by Title VII federal law. The state removed that from this emergency regulation and said it's only going to be medical. Several lawsuits were filed, and a judge in the Northern District issued an order saying the state cannot enforce that emergency regulation, the portion of it, solely the portion of it, that removed the religious exemption. And there was a bunch of reasons and grounds for it. But the bottom line is, that judge also said it's going to apply statewide. So one of the questions we've gotten initially related to that is, well, my facility, my FQHC is down in Brooklyn, and this relates to the Northern District. I understand that I'm in a different area geographically, so does it apply to me? And the short answer is yes, we do believe that it applies to you. An Eastern District judge that would cover Brooklyn, for example, a judge in a different area, said that law from the Northern District, that ruling from the Northern District, is in effect statewide. So again, making sure that we don't run afoul of the federal law and don't want to open you up for any unnecessary liability, the guidance is that you should be, and most providers now are, accepting the religious exemption and accepting requests for the religious exemption. Now, what we have done as a firm, we've worked with our clients to put together form documents, and the form documents basically come in three components. One would be, here's the policy and the guidance that mandates the vaccine. One thing we tried to do with that language for our FQHCs, for example, or hospital clients or ASCs, is reference in that document that pursuant to order or regulation of the state, blah, 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 meaning this is what's required of you. It just has a little bit of a softer approach to individuals within the organizations that believe it's not fair to do this, and helps promote your mission that you're trying to be inclusive of everyone on staff. So that's one portion that we recommended in the policy. A policy itself is not per se required to be delineated to staff under the emergency regulation. However, the emergency regulation, as Sandy will talk about, does require documentation that you have something in place, something written in place as to how you're going to administer it. So that's one way to do that. The other two forms are a religious accommodation request form and a medical accommodation request form. And that then puts it onto the individual employee to fill out that form, submit it, and send it back to you. So again, that's the recommendation with respect to how we treat the religious exemption right now, and also advise staff when you're telling them we are accepting religious accommodations as well as medical accommodations. The religious is on a temporary basis until such time as we get additional guidance from the state or the judicial system in this case. And that the hearing on that case is scheduled for the second week in October. So we would hope to have a little bit more from the judges that are hearing these cases mid to late October. at the federal level, and that would provide us with a little bit more guidance. Of course, the other thing to monitor and pay attention to, as I'm sure you all are, if there's going to be any legislative change. There's a lot of discussion, and I've spoken to many plaintiffs' attorneys who are lobbying against this, that removal of the religious exemption, and there's speculation that the state may, in and of itself, come up with some workaround because, as Jeff alluded to, there may be staffing shortages as well. So all considerations to keep in mind and be on the lookout for, and we'll be putting out more and more alerts related to those issues as they come out.
Sal, can you talk a bit about the religious exemption? So we've gotten a bunch of these things, right? It's somebody says,
Yep.
I'm Christian and I eat and I believe that my body shouldn't be invaded with foreign substances, but yet they've had all of their other immunizations in order to be employed and everything like that. Or somebody says, you know, I mean, these are the kinds of things we're getting. Like, who are we to determine, like, whether, you know, what's a religion anyway? I mean, is it only organized religions? What if somebody says, this is just what I just don't believe in it? That's their religion. I mean, it's, are there rules about what religious exemptions really are and how they can be adjudicated fairly?
So this is, I think it's Neil, right? Neil, this is the $1 million question. And right now, there are some rules, there's some guidance, and I'll go over them with you now. But there's also a lot of unknown. And I'm not trying to just kick the can down the road and say, I don't know, but there's really nobody out there that knows, because there are a few cases, and individuals with clients have said to me very astutely, well, isn't there guidance on this for the flu vaccine? And there are a few cases with respect to the flu vaccine, but they're a couple of years old. They don't relate to such a hot button political and social issue as COVID has and the vaccine mandate. And there are fewer and far in between. As I said, I only found a handful of cases in my research in the past weeks. Now, some of the rules, and it's a bit of a misnomer where people have said, well, it has to be a religious base. It has to be absolutely religious and only the major religions. Well, let's first start there. It's not just major religions. In fact, the courts have said, including the Supreme Court of the United States and the EEOC, that's the federal agency that's going to guide and mandate what's allowed and not allowed for purposes of discrimination, including religion. They have all said it's not limited to just a major religion. In fact, they've gone further and said it's not limited to a basic tenet of that religion. What it is it's a sincerely held religious belief. So a sincerely held or morally held belief that in some way relates to your religion. So, you know, some of the examples we've been giving, and we've received all these requests, and Neil, I know you touched on some of them, but we get them on a daily basis. I can't get the vaccine because I'm Catholic. I can't get the vaccine because I'm Jewish. I got one yesterday. I can't get the vaccine because Russian Orthodox. That in and of itself, I don't think triggers enough of to warrant the religious exemption. That said, where you have to be very careful is how much you push and ask for additional information. So what seems to be basically acceptable is to say, what is the basis or belief upon which that your request for an exemption is based? And, you know, this is a little bit of legal jargon, but I want to read it to you because it kind of explains how we're all trying to analyze this and what we'll be looking at if people do decide it. And against this backdrop, generally speaking, the EEOC has recommended that employers should give deference to their employees saying they have a sincerely held religious belief. And employers should not over-investigate and challenge or question an individual's request for a religious exemption. And one standard that a court out of the Third Circuit, not in our direct area, but would apply to New Jersey and some of the areas out that way, had said, when dealing with the request for religious exemption, does the belief, quote, address fundamental and ultimate questions having to do with, part one, a deep and imponderable matter, maybe something such as life, two, comprehensive in nature, and three, accompanied by certain formal and external signs. Now, in the cases that looked at the flu vaccine, the request, this is where it differs, and you have to be careful because people have pointed out to me that, well, some of those courts have said it wasn't a sincerely held religious belief when it related to the flu vaccine. Most of the cases that challenged the flu vaccine, the reason was it's going to do more harm than good. And that was a quote from the lawsuit. It's going to do more harm than good. That's a medical objection. That's not a religious objection. So what you have to try to determine, and it's extremely tough, and Neil, you hit the nail on the head, a tongue twister there. And the issue is, how are you to judge what's religion and what's not? It's so difficult. Yeah, I'm trying to deal with it on a daily basis. You know, one of the best examples I've looked at to try to address this and trying to explain it is when someone comes to you and says, I'm Roman Catholic, I can't get the vaccine. A lot of the employers have said, well, the Pope has said it's okay to get the vaccine. So how could that be? Now someone comes to you and says, well, it's a little bit more than just being Catholic. It's because fetal cells were used in the testing or administration or the research of this, and that's against my religion because in Catholicism, abortion is no good, is not allowed, and morally, I just can't stand for that. Now, if I was advising you on that scenario, and the first situation was I'm Roman Catholic, it's okay, maybe you can push for a little bit more. And now you push for more and they give you the fetal cells. To me, right now, where it stands, that's enough. That's enough not to question and push it. And if you do question and push it, you should expect you're going to get a lawsuit or you're going to get a challenge with the Department of Labor or EEOC saying that you discriminated based on religion. Now, some people have the stomach for that and are willing to go forward and fight it. Others say, I don't want to be on the news. I don't want to be in the media. I'm going to allow the religious exemption until I get more guidance, until this gets worked out. So there's no great answer, but that at least gives you some guidance.
Is the language that you just used from the EEOC, is that in one of your slides or?
No, that comes directly from a court case. I can send it out though. I can coordinate to make sure. I think it's Maria.
Or maybe just a reference to it in the
Sure.
chat that we could use, because I think that's incredibly helpful and illustrative of what we need to do. The fact that you said that not to do over investigate, I think was the word that you used, or that's there, and fundamental and sincerely held belief. I mean, I think both those things would cover every exemption request we've gotten so far, that otherwise I think we would have turned down.
They typically do.
I think we end up.
I have a question. And the question is, what about they have already, to get the job they have, received vaccinations that fetal cells might have been the original origin. So if it's documented you have already received these, why would these fetal cells be different from the ones you already received in other vaccinations?
And that's a great question. To me, that's where someone is shifting their belief. It's not as much religious as it is political or social. But again, you have to be very careful in challenging that, because there's going to be very creative lawyers. And I spoke to a plaintiff's lawyer who I'm friendly with, and we bounce these ideas off each other so that I can relay the information to you. You know, a good defense is knowing what the other side's offense is doing, right? Basically, I'm in the huddle, so I know what they're saying, what they're going to do, and what they're telling their clients, the employees, are, you changed your mind. And there are court cases that say individuals can change their mind to what their religious beliefs are, or they became more educated on it. They didn't know. And what a lot of staff members will say, you know, the mumps, rubella, measles vaccines, the immediate response there from the employees and their attorneys will be, I got that when I was a child, when I was a minor. I couldn't make that decision for myself. Now I'm informed and I can, and I've learned about this, and my belief is X, Y, and Z. There's one situation where someone changed religions, and it was at a hospital relating to the flu vaccine, and it was given some credence because I think it was out of Ohio, because the person was able to demonstrate a sincerely held religious belief. So, you know, Janice, I sympathize with that, and I agree. And I've had all of our healthcare clients say that to us. It's not without risk to just say, well, you got other vaccines, now you have to get this one. You know, just by illustration, when I was doing my follow-up research this morning, a court in the Midwest found that veganism passed as a sincerely held religious belief when someone objected to veganism. I haven't explored it enough to educate you on how that could be, but a court found that it could. So here, you know, based on what the fetal cell objection has been, that's been raised pretty regularly, I do think that it will get some traction. And in being on calls with judges and courts on this very issue related to the temporary restraining order that I discussed, the judge was giving it a lot of credence about the objection related to testing on fetal cells, or whatever that's worth.
Maybe we can,
Yeah,
I understand we have a hard stop at 2:15, so Sal, maybe we should finish the slides and then handle as many questions as we can on that at the end.
Of course. So
Okay.
the next slide, I'll touch on this very briefly. Federal guidance is expected to come out in the next week or so. The expectation is we're going to see a November enforcement date, and we should have more guidance in October. Generally speaking, employers with 100 or more employees should be covered, and healthcare facilities that participate in or are covered by Medicare, Medicaid. So that's going to pick up everybody else. Again, it's going to align with the state. The state can be more aggressive, so to speak. They can implement more requirements of you, make it an actual mandate. The federal might be a little less restrictive, meaning it might allow for a test out option to specifically say get a vaccine or test out. And I do not anticipate that the federal mandate will remove the religious exemption. I'd be shocked if they did. Might make things easier for everybody, but I don't think that they will. And just one other point, OHSA is going to be issuing the guidance on this. So keep an eye out for that. OHSA has issued some other guidance that I know you're familiar with, the emergency temporary standards. So it'll be similar to what we saw in that vein. And with that, on the OHSA point, you can go to the next slide, please. Because we're short on time, I'm not going to spend much, if any, time on the OHSA temporary standards. I know CHC did a prior presentation on this earlier. If there are follow-up questions on that, just be reminded that it's still in place. It's still a requirement. And consider it also against the New York HEROES Act that went into effect a couple of weeks ago in New York, was implemented. Generally speaking, if you put your OHSA policy in place and your COVID plan in place consistent with OHSA, it should meet the New York HEROES Act requirement. You would just want to verify that because New York does require it. One point to keep in mind in the HEROES Act, if you have an employee handbook or manual, you do need to update that handbook and manual to include reference to the HEROES Act. So again, if you do maintain a policy, and most of you probably do, I know we've done some for FQHCs, update that policy as soon as possible and practical. We're basically putting together a form that just says, you know, we're appending it, see attached exhibit Z or Y, whatever it may be, and you put that plan to the back of it. But I'm seeing state agencies that are investigating these issues. Are they going to do it today? No, they have their plate full. 6 months from now, though, I would not be surprised if you're getting an inquiry from OHSA on the emergency temporary standards, or from the New York or New York City Department of Labor saying, where's your HEROES Act plan? Where's your handbook? I need to see this. And if you can avoid it now, do so.
Okay,
Next slide. I think we're back to Sandy.
Okay. So what do you need to do? A lot of things, unfortunately. So there's a lot of record keeping that we talked about. There's data that you might have to submit to DOH. You also have to develop policies and procedures. They said it numerous times in the regulations and also the FAQs. You might have to submit these documents to DOH. And, you know, in one of the FAQs, they said that the policies and procedures should discuss how you're going to prevent fraudulent documentation. So, you know, the fake COVID CDC cards, how are you going to root out fraudulent cards? You have to identify who your covered personnel is. You have to develop your exemption forms. I would track your religious exemptions because we don't know what's going to happen with these court cases. So any of those religious exemptions that you're granted, and if a court ultimately decides that the state had the authority not to grant religious exemptions, then those personnel that aren't vaccinated because they have a religious exemption, they would then fall under the definition of covered personnel that are required to be vaccinated again. So figure out how you're going to track all this. Next slide. You have to provide notice to staff if you haven't already done so. You know, Sal gave a good example of a phrase to use. You know, the state requires this. that you have to implement it. You have, because of the state regulations, you have to ensure your staff are vaccinated, at least receive the first dose by October. So, you know, give notice to staff, and again, keep records of everything and document everything, because it's more likely than not that you'll have to provide this information to DOH. Okay, I think that's the last slide. I think we have a few minutes for questions.
Thank you so much to the Garfunkel Wild team. Lots of questions flying in the chat. The first one is, I wonder if you could just talk about federal preemption versus state preemption, since we are expecting that the federal vaccine mandate will include a religious exemption. Where should health centers abide by?
So I think the answer to that is we'll have to see what the law says, but as a general course, the way it works is that you have to follow the stricter of them. So if the federal law says that people could either have vaccines or be tested, and the state law says you have to have vaccines, you have to comply with the state one. With regard to the religious exemption, like Sal said, we expect the federal one to have that in there. The state one does not, but because of the court case, effectively the state one does, at least for now, subject to what happens over the next month or two.
Thank you, Jeff. And a question about HEROES and the HERO Act and ETS. Do we need to follow both?
Yes, you need to follow both, but the way the New York HEROES Act is drafted, it's that if you have a policy in place that meets the requirements of the HEROES Act, that would suffice. So if your ETS plan should be enough to cover it. And I would just reference it in your handbook. Separately, you'd have to reference in the handbook that you're in compliance with the New York HEROES Act.
Right, I just want to point out, I know it's not really the subject for today, but the OHSA stuff, like I think a lot of people are ignoring, and we've seen clients where OHSA has come in and been enforcing it and issued very significant penalties relating to not having the proper plans in place. So I think you need to take that seriously.
And if I could just jump in on one question that I saw that I think is important on the accommodation piece. Someone had asked, generally speaking, can I say that the reasonable accommodation is unpaid leave? Or people are asking, it's an undue burden on me. I can't have you treat patients if you're not vaccinated at all. So I'm glad you got the religious exemption. Thank you. Good luck. You're fired. Both of those, I think, are a little bit too aggressive under the law positions to take. And the reason for that is the response that I'm getting again from my friends and colleagues doing the plaintiff side are, for 20 plus months, you've allowed individuals to work the front lines with PPE and masks. And courts have said, and the EEOC has said, reasonable accommodations for individuals could be lesser restrictive alternatives, such as masks and testing, or PPE and testing and masks. So what I would suggest is a lesser restrictive alternative, full PPE masks, but you stay on top of it and you remind them that based on what OHSA has said and what other entities have said, they need to wear that mask all day, every day inside, unless they're 6 feet apart and having something to eat or drink. And if you see them violating those rules, then you cite them, put a note in the record, and take action from there.
Some health centers are worried about being open to legal risk from vaccinated employees if they are not effectively monitoring the exempted employees regarding PPE, social distancing, and face shields. Can you comment on whether vaccinated employees might have a case against their employer for the way they're managing their exempted employees?
So I think the case I mentioned before, the FQHC mentioned before, where OHSA came in was based on a complaint from a vaccinated employee about not having those things in place. So the answer is yes, you could be subject to it, but that does not mean that because you're trying to protect against that, you go ahead and fire everybody who has a religious or medical exemption, right? If they have a religious exemption, you're just trading one lawsuit for another lawsuit. So unfortunately, you'll need to, and I get that you're trying to treat patients around a health center, and this is just another burden, but unfortunately, it's another burden that we have to deal with right now.
And just, just to add to that, that's why, like, when you develop your medical exemption form and you develop your religious exemption form, make sure it's filled out. For the medical exemption, you need to have a physician or an NP certify it. It has to be on. There were all of those requirements in the regulation. Make sure you comply with the regulation. Make sure your forms are solid so that you can say, you know, we complied with the law. We gave them a reasonable accommodation. We required this, you know, nobody ever brought it to our attention that they weren't wearing the mask. In our presence, they always did. So you just, your policies and procedures and your forms should all provide you a level of protection as well.
And then the last question that we're going to get to as part of this discussion, can you talk about how an employer might prove an undue hardship to themselves to manage the different exemptions allowed under the vaccine mandate?
So I think I will give the same answer that I gave before. I get that it's a pain to deal with this, but to be able to establish such an undue hardship that you're overcoming a religious exemption is a very, very, very high standard. Sal, maybe you want to add to that?
It is. It's going to be very difficult. I think Jeff summed it up. It's hard to do, to demonstrate. I suppose if the individual, if you're in a only example I can think of, a highly sensitive area with patients, cancer patients, young adolescents who are extremely vulnerable, and this is the only person that can perform that duty and they're not vaccinated, that might be an undue burden on you because you're not going to be able to perform those procedures and care for your patients. Short of that, you can reassign the person as long as you're not demoting them, taking money away, or making any other type of truly negative adverse employment action. Or again, PPE, masks, and testing. Those seem to be the alternatives.
And keep in mind, they've been, you know, before October 7th, if you've been using these people in that setting, in that sensitive setting, then it's like, you know, what happened on October 7th that flipped the switch that it's an undue burden for you, and PPE or an accommodation wouldn't address it.
Sandy,
Yeah.
Jeff, Sal, thank you all so much for your willingness to do this, especially considering the guidance literally just came out from DOH 2 days ago. We really appreciate it. I want to reassure everyone on the call that we will be sharing Garfunkel Wild slides. The recording will also be made available, and Garfunkel Wild slides do include contact information for Sandy, Jeff, and Sal. So I think it's definitely above board to use that contact information to reach out to them. Thank you.
It was our pleasure.
It was our pleasure. Thank you all, and best of luck navigating these difficult issues.